way. Welcome to the second session of the working group in the Community Building Subcommittee. This one is led by Iris Rad, our chair of the UK Law Commission consultation paper response regarding their proposals around a third category of property being a data object. So Iris, over to you. Did you want to summarise what our focus is for today?
Absolutely. So we'll take the approach that each week, each Friday, we'll be going through approximately 5 chapters worth of questions. And so this week we'll be going through chapters 1 to 5. Now chapters 1 to 3 don't have any questions. So we'll be focusing on the questions in chapters 4 and 5. And then next week, hello, welcome Nathan. Next week, we'll be going through the questions in chapters 6 to 10 and so on and so forth. So having this approach, we'll be able to focus on the discussion, the meat of the questions, and then we should finish a few weeks before so that we have ample time to continue the discussion and go into any depth as needed.
Fantastic. Well, do you want to kick us off with the first question?
Absolutely. So this one is the only question in chapter 4, which is this proposal of the third category of personal property. And the question is that it's proposed that the law of England and Wales should recognise the third category of personal property. Do we agree with that approach?
Well, maybe I can offer some thoughts to kick us off, get the discussion going, and either speak up or put your hand up, and Iris and I can facilitate just to manage the discussion. I agree with this proposal, and I understand that the passage of this law reform could actually take just as long, if not longer, for the common law to evolve, as this consultation paper acknowledges. But I think that the significance to the market of seeking to clarify the position would mean volumes for market certainty and ability to transact more confidently. So I agree, but I would really like more meat around what the transitional or transition relief looks like, as well as the new causes of action and remedies when our property rights, our data objects are interfered with. And so I've got a couple of examples to go through, perhaps after we've heard from everybody, but just to play out really in the context of the ETH Classic hard fork, and now with the merge, the transition from proof of work to proof of stake, what that might mean if we have a third class of property. So happy to walk through that example after we've heard initial reactions. Nathan, you're nodding vehemently. Did you have an opinion?
Yep. Is my microphone working?
Yes.
Great. Yeah, so I was sort of thinking that it would make sense to have a third category if we're thinking about it as digital, which is a bit, it's being overused now. The words are always being thrown around. But if we imagine it as something that's used to tokenize real world assets, which will be a huge utility in crypto for blockchain by itself, but also as DeFi starts moving towards allowing collateral through depositing or collateralizing tokenized real estate or tokenized real world assets, it becomes really important to sort of acknowledge the existence of this third category right in between the two spectrums of it's tokenized, it's digital, and it's real, physical. And it sort of gives a bit more meaning to the idea that just because it's online doesn't mean it's not real. It's real online. So it's hard to visualize it, but if you're looking at it as, okay, there's a real world that we're touching with our hands, and there's an online world that we're touching with our, everyone's laughing what I just said, thanks guys. And there's a digital world that you're touching with your mouse and your clicks. That sort of gives it more meaning if we have a law around a third category. My take.
Yeah, agree. And then probably gets even more blurry when we've got tokenized real world assets, which I think that's a case study in itself, because in a sense, the source code could meet the 3 criterion for a data object. But then when you look at the broader scenario outside of the electronic medium, then you do have contractual rights or a statutory regime around the real thing.
Yeah, 100%. And then even if we're looking at who bears liability if something bad happens, or how do we authenticate that this tokenized asset is still protected in the real world, right? That's a huge issue of like, okay, we've tokenized a house, but who's watching the house all the time? Because that isn't on the blockchain, and maybe we can use an Oracle solution, but how verifiable is that if one person's watching it? So it's sort of, it's not just for tokenized real estate, it could be for gold or for anything else. It's just, how do we authenticate without regulation that what we've tokenized, what we're holding, is safe and secure, as we know it is in the blockchain already.
Yeah, thank you, and welcome to the few more people, Campbell and Yana, that have just joined. We're sort of moving around the grounds to get your initial impressions on question 1. So thank you, Nathan. Iris, did you have something to add on this one?
Yeah, there is some discussion in the consultation paper about the fact that it's been this things in action. So the 2 existing types of personal property, things in possession and things in action. There's been some discussion around things in action being a residual class of personal property. And so perhaps it's worth to discuss, to go into a little bit about that, and why, even though it can be taken as a residual class, and the courts have recognized that it might not be necessary to answer, it might not be necessary to create a 3rd class. So perhaps we could speak to that as well.
Yeah, so why it is or isn't sufficient. Okay. Campbell, did you feel comfortable to offer a point of view at this stage?
Yeah,
Welcome.
I'm afraid I've just joined, so I'm missing out a bit.
No worries. Well, we can warm you up and feel
Please.
free to jump in at any time.
Thank you very much.
Varun, any thoughts from you?
I probably might not be as helpful. I'm not of a legal background. My only question was, when it comes to a 3rd category of personal property, and what happens in cases like the Tornado Cash, etc., when is it a data object in which you own even if you did not want to own, kind of a thing, when someone gives it to you, and then you officially have control because it's in your wallet?
Yeah, I think that's a great question, and it would go to it goes to like a next level question, because if your risk profile will be determined, by centralized exchanges by reference to your wallet and what is in your wallet, the fact that property has been dropped to you that is dirty, or is got a tainted history, what's the onus upon a person that has suffered that kind of attack, or is the victim of that kind of attack? Their property rights haven't been interfered with, but their risk profile and their reputation has. And this, I think that is the key thing missing from this paper. As we said in the session last week, it doesn't go to the level of digital identity and reputation and ownership when it's trying to grapple with, do you control a token, and how do you prove that you control the wallet where you can direct the dealing of a token. So I think it's a really good point, and maybe we try to work it through and propose not causes of action, but burdens of proof. So do you, if you have to check your wallet every week or at the end of every month and make a statement, these are the tokens that I have actively gone out to own and purchase, versus these are the ones that have been airdropped to me. And this happens a lot with airdropped tokens that are also, designed to lead you to click click on them and take you to malicious software. It's not just the dropping of dirty or dusted ETH from the mixing protocols, more of which may be sanctioned after Tornado Cash, but it's also that airdropping activity. So maybe we put some thought around what reasonably could the mum and dad do, or the teenager, or maybe there's a few different demographic or profiles that we say what's not too much friction to really prove what their accurate risk profile should be. Yeah.
Can you just repeat what you see the danger as? Johnny, you mentioned Jared's reputation and I think something else. Can you just repeat for my benefit what that means?
Yeah, so the Financial Action Task Force, or FATF, have recommended to all VASPs or virtual asset service providers, which includes centralized token exchanges, you know, the likes of Binance US, Coinbase. They have recommended that the originator and the beneficiary information is collected before token transactions can be sort of deposited or withdrawn when you're dealing with a regulated VASP, if each country picks up these recommendations. And we will increasingly see these token exchanges disallow deposits or disallow withdrawals where the wallet address is coming up with red flags, because the blockchain analytics programs and the software that they're able to access can read from the publicly available blockchain information that what tokens are in a particular wallet that a person is trying to withdraw from a centralized token exchange. So rightly or wrongly, they will have to risk profile if these regulations come in, and me using reputation is kind of a shorthand, lazy term for what your risk profile score will be. So it limits your ability to transact.
It certainly would. Isn't the whole point, if it's a fungible asset, that anonymity should be preserved? If I give you a $50 note, you care not where it came from or how I got it. Isn't that the benefit of these medium of transactions?
Well, this is what we're seeing in the policy discussion around privately issued stablecoins as well as CBDCs. One of their design principles is to make it as analogous to or same as cash and the qualities of cash. And yet we haven't really solved that yet. The thinking is still out because there is this desire for the continued over collection of personal information.
Yeah.
So it's not resolved as far as I can see, but it's an ideal.
But if it's designed to be as analogous to cash as it can be made, and as amorphous as cash, why go to the trouble of identification? You say it's a reputation.
Predominantly, yeah. So the money laundering and terrorism financing standard setter is saying that the risk is too great, that despite the ideal of anonymity and the importance of cash-like transactions, or really your autonomy to be able to privately transact where you wish to, they're saying that with blockchain and the velocity in which tokens can move, and therefore it can fund crime, that the trade-off should be made against anonymity, and therefore we should be able to trace with all of the originator and the beneficiary information. I don't agree, but that is the recommendation.
Well, that would be an argument for having tracing on cash.
Well, and why we might not have cash and why we might have CBDCs issued to surveil.
I cannot see what the objection is to making it completely amorphous.
So on the technical side, a lot of the builders and the innovation to preserve anonymity, we call this zero knowledge proofs.
Yeah.
So, you know, I don't have to say that my name is Joni Pirovich and I'm 34 years old to get, you know, a $5,000 unsecured loan and perhaps some other information. Algorithms can be built to look into my wallet, and if I've got some tokens that represent, you know, my attributes that make me eligible for this particular unsecured loan, then that algorithm should be able to look in, prove that I meet the requirements, but then the proof is generated. So I'm not actually leaking or oversharing my personal or my sensitive information. It may result in a spending transaction or approval for a loan or whatever you may think. But that zero knowledge proof mathematics, I understand there's still a lot more work to be done before we can rely on it and before it's a reliable alternative to the over collection of personal information and KYCing everybody to manage and to deter the money laundering and terrorism financing risk.
I understand, Joni. Well, I understand the argument. I'm not sure I agree with it, but I understand the argument.
Yeah, no, I love your points, and we just need more voices reflecting those arguments because they're certainly not being aired much.
No. Jessica, let's make my other point. I don't want to hog the conversation, but
no, you're welcome.
The juridical nature of these animals, it seems to me it lies more in copyright than anything else. It's a piece of property. It's hard to put property in it. Alienable, but because a token can be transferred. But is it not? Its juridical nature is a literary work of copyright. It appears on a chain, and the right to enforce it is not enforceable like other property because you can't sue the chain. It's just the token that's distributed. But it's a copyright in your key to the chain. Just like it was in the old decision of the High Court decision in, name escapes me now, that a 7-bit token on a copyright is a copyright in 7 bits as a literary work. Is not the same with a private token here?
This actually is one of my fundamental issues with the second criterion of does it exist independently of the legal system, and the legal system recognizing copyright authors. And around the world, there's a bit of difference as to whether you register or if it comes into existence at the time that it's authored. But my big challenge here is exactly this, that if you are the author of the source code of a contract that is deployed, you technically are the author and the point of responsibility and liability for actions done with that code. But see, the Web3 developer and the builder industry are vehemently against this because they don't want to discourage or stifle developers from that innovation, even if they do it through a limited liability company. And from the US perspective, they go further and they say the expression of code is freedom of speech.
The First Amendment,
but if you at least accept that it's a copyright work, then it doesn't exist independently of the legal system, and so nothing meets that second criterion.
It seems to me, on my unskilled mind, that if it's not copyright, it's not property at all.
And actually, a lot of source code is launched under the Creative Commons license.
Yes,
So if they've turned their mind to actually putting some reference to whether they retain commercial rights or it's under CCO, but we have a lot of cases where there's no reference to what the intention of the source code author is, or from what entity they've deployed it, or treat their keys as owned by. So,
but if it exists, I'm not talking US here, but if it exists just on the creation of the expression in source code, and any object code created from it is an adaptation or translation of the same source code. Is it not true then of private keys?
yeah, I think where you mentioned the other works, the other derivative works,
Yes.
Again, this needs further consideration, because if you accept that you are the copyright author,
Yeah.
and somebody, the common word used is they fork your code. So you've come up with a DeFi protocol. Nathan's now copied that. He
How dare you, Nathan?
but maybe he's slightly adjusted. Like in his white paper, he writes about some different things coming in his roadmap that go further than yours, but it's still that same functionality. The question is, because he's copied that functionality, do you still remain liable for his use?
No. Unless it's a trend, well, I'm not at all, because the use of it by Nathan is his use of my copyright if it's a translational adaptation, and that's an infringement. How could I be liable for his act?
Well,
it's not my act.
There's something interesting here to touch on with like the idea of an open source code, and essentially with crypto and blockchains, the future is to be quite interoperable, right? So that's the logical and the philosophical basis of crypto at the moment, to move towards being interoperable. And as such, there's sort of an idea of having public goods, so free public goods, and one public good in crypto is open source software and code.
Yes.
And of course, that just means people can fork and fork and fork. So there was recently a new DeFi protocol that allowed for trading NFTs, and that was great, and everyone's really happy. And then there was a fork, and then the creators of the fork took all the money and netted about 900K, and there was no consequences. The result was people are a bit more scared of using the original platform.
Yeah,
of course. Yeah. But the actual original protocol and the builders of that had no real IP. Yeah, there was no ownership over it. They owned the website, right, and the domain, so they had the authentic website, but the actual code itself was out there for everyone to use. And that goes back to the idea of code for the first time since the first iteration of the web, when it was interoperable, being an open sourced, being a public good for everyone to use freely. So it's sort of,
but the open
it's a whole new idea.
Yeah, it's way beyond what that is I'm familiar with. But the open source simply means that there is no remedy for breach, doesn't it?
Currently,
the still exists, doesn't it?
Currently,
everyone's free as a licensee to use it.
And actually, we saw this play out with Uniswap, the decentralized exchange protocol. So they released their version 1 software as open source, and I'd have to refresh myself on the facts, but they may have even mentioned CCO, the Creative Commons license. They left themselves open to what's been coined a vampire attack. So the copycat protocol, SushiSwap, they copied the code, but they did the one extra thing. They also launched Sushi Token, which was an incentive to draw away the liquidity from the Uniswap protocol to SushiSwap, and really to get the liquidity back and maintain its market share. Uniswap, we then saw issue actually airdrop Uni tokens. Now, by the time we got to version 3 of the Uniswap protocol, they also had a bespoke license which said, if you, and I'm paraphrasing, if you are using this code for open source and community benefit and public goods, then that's okay. We accept and we license for that use. But if you are a commercial centralized entity accepting fees for your use of this protocol, we will charge a license, charge you to license this software from us, and it will go to the Uniswap treasury. So
is it in the open? Is it in open? Is it in the open domain at the moment? Is it? We say public goods. Is it?
so that people can exchange one token, like that's the public good, is that's the marketplace or the exchange where I can swap my ETH for uni tokens if I want to, or vice versa. And I don't need to KYC currently. It's quite a frictionless process for me to connect my wallet and use the service. Yeah. So I think so it might be useful in our response to go through the Uniswap, SushiSwap vampire attack and speak to the licensing rights to evidence that is code or smart contracts that are deployed on these decentralized global blockchains. Can they actually fit within existing copyright laws?
Yeah, exactly. Yes, yeah. It's going to be a difficult fit, I'd imagine.
Yeah. Yeah, and if it is difficult, could the law or statutory reform play a role in making things clearer for market participants?
I just thought it would have to, yeah.
Yeah. So I haven't heard yet from Jana. Jana, are you in a position to speak up if you'd like to?
Yeah, thank you, Joni. As a non-lawyer, trying to follow the conversation, struggling slightly. I was just looking at the European Commission's latest proposals, and we talked about it already, Joni, the Data Services and Markets Acts and the Data Act and so on. I can't really find anything though that might overlap or be similar to what is proposed here. So what the UK Law Commission proposes is entirely novel, I suppose. Yeah, I guess I do not have that much to contribute to Q1, but let me see how I go with the other questions further below.
Yeah, no worries. Well, and I know we're almost halfway through and we've spent all our time on question 1, but it's a meaty question. And well, so I'll try to be as quick as I can, but what we saw with the ETH Classic hard fork was a remedy brought about by social consensus, which was, and it is quicker than any existing legal system could deliver, or collection of legal systems.
Yeah.
So with the structure of the DAO launched on the Ethereum blockchain in 2016, there was a governance mechanism built into the smart contract where if somebody wanted to exit from their investment, they could quit. And there was a 14 or a 28-day period which it took to actually get your investment back out. And that was the saving grace in this case, because it only needed that amount of time for enough of the Ethereum community around the world to come up with the hard fork approach and implement it before the stolen ETH was released to the attacker's wallet. And so what we know is the Ethereum Classic chain, it does recognize the attacker's ownership of the stolen ETH. But what we know is the Ethereum blockchain, it didn't. The change that was implemented at the block where the hard fork was implemented was it allowed anybody who had invested in the DAO to basically put their DAO tokens into a new smart contract and recover the ETH that they had deposited. So it was basically giving the remedy of contractual rectification as best as possible to put the parties in the position before the unintended event or the attack. But we haven't seen any criminal actions against the attacker. We don't know the identity of the attacker. There's been some allegations where people think they know who it is. But the question of, is it actually a criminal act? Was it true to say that the ETH was stolen when it was the developer or the attacker taking advantage of vulnerability in the smart contract code? So is it truly a criminal act if the developers didn't take all steps necessary to ensure that the code couldn't be wasn't vulnerable and couldn't be manipulated? And as I understand it, the developers were aware of this particular bug and they didn't act quickly enough. I mean, once the attack started happening, then they were very quick to get into gear. But one of the remedies, so to speak, if we see this kind of attack happen again and on a much larger scale than $50 million worth, you know, should actually the law recognize that the blockchain community, whether it's made up of proof of work nodes or proof of stake validators, that really in their smart contracts, they need to design a holding pattern or a period that they think it will take the community to reach consensus about how to get to a rectification state. Does that make sense?
If redress is awarded in a case like that, then it seems to be a little different from the case of a man who was robbed after he left his door inadvertently ajar so the robber could enter. What's the difference? Theft.
Forgive me, it took me a while to take off mute. Well, and this is the thing. So if we're going to recognise a third class of property, so as not to leave our door open, does it require cybersecurity training or basic due diligence training to be able to read a smart contract cyber audit to understand what vulnerabilities are there when you're getting involved?
But if we deal with the criminal law, we don't need to. If the action against if it's a crime for a robber to enter an open door and not be guilty of an offence, he's still guilty. Doesn't need special treatment of the law for that, surely.
There's one big problem with like smart contracts and coding at the moment around for cryptocurrencies, and the best way to put it is that there are smart contracts but smarter hackers. So no matter what we do, how much security there is, all the research, all the R&D that goes into finding the best contracts, no matter how many security firms we partner with, there's going to be hacks no matter what.
Yeah.
Even times that you know, you've had like in the industry, there is like Chainalysis, there's Certic, and there's quite a few really renowned and reputable firms who have read through it, and it's just been hacked. So with your analogy, it's like no matter what, the door is going to be ajar, and if it's not ajar, they're going to bash it down, because there's always going to be a way around the issue. Like in this idea, in this world, there can't be. It's if they've made the effort to protect themselves, that might have to be what counts, because there's always going to be a way around it. There's always going to be one little mistake, one time where there's so much volatility in the market that the whole thing crashes, and then there's a DDoS attack, or there's no access to any to even connect into the mainframe. And if you can't connect to the server and you have an open position, if you're borrowing or you're you have an open position and your crypto is reaching the liquidation phase, and it's blocked because there's too much volatility, then you're finished. So people will start buying it for cheap, and then you lose. And even though it isn't a direct exploit, there's still issues that we can't even foresee. And if we foresee, we say, okay, we fixed it, so this won't happen anymore. But then the next guy's like, oh, I think
we're going to do it. Yeah.
So it's hard to sort of get around that when there's
But isn't the point of the present discussions applying the existing criminal law to it?
Criminal law as well as traditional contractual law remedies.
Exactly. But if it's going to be a redress, that's scotched because there was a negligence on the part of the coder that left that to intervene. It's still theft, isn't it? It's not, in an American sense, it's theft. It's infringement under Australian law. The Copyright Act. There's no license to the Copyright Act.
Yeah, and actually the litigation that I've got on foot at the moment, we're actually trying to prove what property was held
Ah,
before the hard fork and whether it was the same property that was held after the hard fork.
yes.
So with the Ethereum network, it's my holding of Ether is in theory meant to be my right to spend the Ether on the Ethereum network.
You
And it's the
count
same
that,
thing after the hard fork.
you're counting that right as a juridical right?
With
It's like a
hesitation.
right to work. It's not a juridical right.
So I pause because it's not just a right to spend.
No,
It's
no.
also a right to spend in accordance with any license that exists, but also a right to speculate because ETH is listed on many token exchange, which is outside the control of the Ethereum Foundation or any one Ethereum miner. And so that's where the use of the token has gone beyond its initial intended, perhaps its initial intended utility or what it was brought into the world to do.
Yeah.
So when I'm trying to understand my rights in relation to enforcing something against someone or holding them liable to give me remedy or redress,
Yeah.
if they never intended that it would be for speculative use, it doesn't feel right to go back to that, the author to claim that.
If it's truly a right, there must be someone against whom you can bring it, enforce it. It's a kind of jus tertii attitude in common law. There's no one here who can. I query whether it's a right. It is simply an ownership copyright.
Yep.
There's no contractual base, is there?
It's hard, and I think that's why the two next pieces of work for the UK Law Commission being conflict of laws and the sort of the personhood, the legal personhood status of DAOs is really important work.
Indeed, indeed.
So once these three pieces come together, then we have a holistic policy stance. And the consultation paper actually states this, that we need to get through these pieces of work before we can attempt reform on regulatory, tax, prudential.
Yeah.
Because this is the framework.
Yes. It's easily the present framework. No, thank you, Jenny.
I'll just pause there for anyone else that wanted to speak up if that's
Jenny, just general question. Now that we know that Treasury will conduct its token mapping exercise soon-ish, how do you think does this fit in here? Or are there any, I don't want to call it overlaps, but any avenues that need to be further explored?
Yeah, I think that what the token mapping will show is that they're skipping a step.
Yeah.
So they're trying to map the tokens or, the major uses of tokens that we're seeing to what are the tax buckets and what are the existing regulatory buckets and where are their gaps. And so I see it as trying to leapfrog the core foundational work that the UK Law Commission is doing. I mean, maybe it's a shortcut and it's a good one because we may get more sensible and more quick reform, but I am minded to really get into the teeth of this UK Law Commission work because it seems to be setting the proper framework.
Yeah, I reckon the UK Law Commission is playing the long game, whereas Treasury is coming from the mid to or short to midterm perspective, perhaps. Cool, thank you.
And they may converge. UK is doing sort of bottom up. Australia is doing top down, and with both of their perspectives and insights, I hope that it will be better holistic policy, but we shall see.
Yeah.
All right, well then I might move on to some of the other questions with the time that we have left. Iris, did you want to take us through the chapter 5 ones, if you're still
Yeah,
there?
absolutely. I think there are 5 questions left. I'm not sure if we'll get to all of them in this session, but perhaps if we run over, we can answer the rest in the next session, Joni. So, and a few of these I think we've touched on some of these already. So the next question, we propose that to fall within this 3rd category of personal property, assuming that we've said yes. The thing in question has to be composed of data represented in an electronic medium, including in the form of computer code, electronic, digital, or analog signals. Do we agree?
I think that it makes sense as one of the initial criteria, but it does fall down, I think, with the tokenized real world assets. And unless we have a standard that says in your ERC 20 fungible token standard or your ERC 721 non-fungible, that if the rights and obligations of the fungible token, so it can be used as a closed loop payment method, it's got some utility, it gives you access to discounts or something. If those actual terms are written in plain language within the source code, or linked to a document where we understand the integrity of it and the versioning, then again, does this meet the 2nd criteria of independent of the legal system? Because now we're actually coming up with more of what would look like a typical legal contract. So to try to get certainty, I think we jump back into thing in action if we can clearly identify the counterparty still, or the author. Anyone else have some thoughts on this one? It's basically the container, allowing that it's a new form of electronic medium in which we're going to interact with. So it seems sensible, but I think it falls down later on.
Yes.
Okay, well, maybe the next one, Iris.
Yeah, sure. So we propose that to fall within our 3rd category, the thing in question must exist independently of persons and independently of the legal system. So Joni, I think you've mentioned independently of the legal system. Yes, Campbell, did you have something?
I think it would be hard to make sense if it was independent of the legal system. Underpinning all this must be enforceable and understood rights and obligations. And whilst you cannot pin down an obligation against someone specifically as a party, it's the problem of privity is that you cannot enforce it at all. It's not enforceable. It's ruled by custom, but not by law.
Well, but this is the thing. So the way I expect it would play out is there has to be, if it exists independently of the legal system, it's because we're relying on a decentralized global community to act on a harm and deliver something that is like rectification.
Yes.
And only with those sorts of bargains, so to speak, where you know that you're relying on community consensus and decentralized models of governance, that I think that this criteria could be met. And if that is the presumption, then it's about enforcement across the miners or the validators as to whether they've actively participated in righting a wrong on their network, and what are the penalties for them.
It sounds not a legal issue, but an equity issue. Equitable remedies of some sort here because of unconscionable behaviour, perhaps, or negligent behaviour, but not the law, not common law.
Yeah, it's probably the Web3, there will be a contingent within the Web3 industry that says if we do seek to regulate or put more conditions on the miners and the validators or whatever the word is for whatever the consensus mechanism is of the blockchain, that is in essence censorship or government interference, which is makes the blockchain and the integrity of it ultimately less reliable. It's not that same level of trustlessness, and so that's to be balanced too. And we're already seeing some attempts at interference with Ethereum miners with the Tornado Cash. You know, could they be subject to penalties for validating a block of transactions where they could have done chain analytics software to see what dirty transactions are coming in and not include them in the block? And if they do, should they be penalized? So we're starting to have that already. But I don't think that there is a lot of information coming out about how aggressively sanctions compliance will be enforced against the miners.
No. But if it's an equitable remedy, then no one's looking for damages. And everyone's just right the wrong, but not as common law would go after damages. And that might then require a negligent or wrongful certifier or someone else to make good the formation of the error, whatever it was that made it misconstrue transaction. That's equitable, and that should not be beyond the wit of anyone.
And so that becomes hard in one of the earlier examples we gave, where Campbell, you were the author, but Nathan copied it. And so
that's right, yes, and I told him off for that.
Yeah.
Don't do it again, Nathan.
All hypothetical. But see, and this is already what we're seeing when there's an exploit, a smart contract exploit, and maybe $20 million has been stolen. Actually, the problem is 10 and 20 times larger because 20 other protocols copied that code and have the same vulnerability.
Yes, yes.
But the communication networks are not good because Campbell, you might not know of the 19 that have copied. You might only be aware of one.
I have no means of knowing. No.
Yeah.
Which means that the only person left standing to receive the odium of the transaction is going to be the certifier or the coder or whoever allowed or enabled this to happen. And the remedy is not in damages.
It's in equity or things that replicate equitable.
Yes. Unconscionability and those sorts of things would play a part, but not damages. And I can't see, in the absence of willful neglect, that any criminal role. There's no mens rea by the coders or the certifiers.
Well, actually, what constitutes willful neglect is playing out in another recent collapse with Luna and Terra.
Yeah.
And as a defense to criminal allegations, the founder Do Kwon is claiming that he had true belief that this algorithmic stablecoin would work and that they had enough risk procedures in place that they could withstand, and they were robust enough to withstand attacks.
This was subjective only, yeah. Because it turned out not to be.
Yeah, that's right. So proving that willful misconduct, there are some people that even objectively say he acted and he conducted himself, that he did have the belief and he was getting more developers involved to increase the integrity and the robustness of the protocol, because they were coming under increasing attack for others, market participants, to prove that it would fail for fun and to make a profit, as we saw.
But to be criminal, it's got to be subjective intent. Mens rea.
And it seems that we can't prove that.
No, you never prove that. And no matter how many people say he should have foreseen it, the fact is he didn't.
Well, and this will play out with Tornado Cash too, because there are allegations that the developer knew the protocol needed to be used for money laundering and terrorism financing.
I see. Yeah.
But it's yet to be seen what evidence they're relying on to prove that he knew that or he had that intention.
Which is very hard to prove. Subjective intention, very hard to prove.
Yeah. All right. I know this is a little early for the session today. Forgive me, I'm going to have to close. Iris, did you want to point us to what we'll deal with next week?
Yep, absolutely. And just before that, Nathan, it looked like you wanted to say something earlier.
Sorry,
Yeah,
Nathan.
no, that's all right. Just one really quick thing I think is quite important to mention for question 3 is the idea of permissionless and permissioned blockchains. If you have a public blockchain, that's what we want, Ethereum and general purpose blockchains, then that's great. And that's what should be independent of persons or the legal system. And that doesn't, and clearly right now we aren't very decentralized. If following Tornado Cash, everyone started blacklisting, which has resulted in the potential censorship at the base layer on Ethereum in regards to, I'm not going to go into too much detail on what this is because it'll take up too long, but in regards to flashbots and sort of democratizing MFE, which is a cool idea, but it's terrible if they continue to censor certain addresses. And then we have private blockchains like that are owned by one person, so it's really efficient, but it's not decentralized. So like JP Morgan's Onyx. Then there's consortium blockchains and hybrid blockchains, and they're all really different. And the way we can view them has to be completely different. So either we're saying yes, 2 has to be independent, in which case it will be a public blockchain. And then there has to be an underpinning structure to how to enforce it that isn't reliant on one legal body, whether it be creating an on-chain government and enforcement process through slashing tokens. So if you do something wrong, you lose your tokens, which is sort of a game theoretical take on how to manage blockchains and mining. And then it gets really different if we're doing private blockchains and permission blockchains, because they can be definitely dependent on specific people and companies and entities or a legal system. So it just really depends, and that's why it's sort of like at face value, just to say yes or no without going into depth about what type of looking at is a bit risky, I think, here.
Yes,
Good points. Yeah.
Perfect. Thank you for that, Nathan. So perhaps next week then we'll start from question 4. And we might also give as we'll be going through chapters 6 to 10 as well, if we can get to that, perhaps we'll give a bit of a summary of those chapters as well. I note that I didn't go through it in last week's session. So
that's okay. We've still got 10 weeks to go. All right. Thank you, everybody, for your contributions today. Please, if you have any issue with what you said, send an email to jp@lawfidao.com and we can remove your voice and your face and your words from the recording before it's posted to the YouTube channel. But really appreciated the conversation and hope to see you in the next one.
Thank you, Jenny.
Thank
Thank you,
you.
Iris.
Thanks, guys.
Nathan.
Bye.
See you soon.